5 seconds to go. Start. Such applications could have been filed only after framing of the charges. The same have been intentionally filed at a pre-charge stage of the trial so as to delay the framing of the charges. He submitted that though the appellant is entitled to file an application for discharge, the same has not been filed only in order to protract the trial. He submitted that the totality of the circumstances would reveal that it is the appellant who has been protracting the trial. It is submitted that as the appellant himself is responsible for protracting the trial, he cannot be permitted to take the benefit of the same. The learned ASG submitted that unless the triple conditions as stipulated under section 45 of the PMLA are satisfied, no person accused of an offence shall be released on bail. It is submitted that in the present case, this court itself by the first order has found that the appellant was not entitled for bail on merits, and as such the second condition stipulated under section 45 of the PMLA that there are reasonable grounds for believing that he is not guilty of such offence would not be satisfied in the present case. The learned ASG further submitted that the appellant is a very influential person having occupied the office of Deputy Chief Minister of Delhi when the crime was committed. He submitted that if the appellant is released on bail, there is every possibility of him influencing the witnesses or tampering with the evidence. Dr. Singhvi in rejoinder has submitted that the contention that the trial is being delayed due to the applications being filed by the appellant under section 207 CRPC is totally incorrect. He submitted that the said applications were required to be filed since the prosecution had not placed on record the documents exculpating the accused persons by placing the same in the category of unrelied upon documents. He submitted that in order to avail the right of a fair trial and in adherence to the principles of natural justice as encapsulated in section 207 CRPC, the appellant was forced to file such applications. However, each of these applications were vehemently opposed by the prosecution. It is submitted that the said material ought to have been placed on record by the prosecution themselves. However, for the reasons best known to the prosecution, they have not done so. He submitted that the appellant has filed only 14 applications in ED case and 13 applications in CBI case, and that all these applications have been allowed by the learned trial judge. He lastly submitted that even as per the prosecution, if the entire unrelied upon documents are to be supplied in digital form, it will take a long time. To support his submission, Dr. Singhvi places reliance on the compliance report dated 7th May 2024 filed by the Assistant Director of ED, which would fortify this position. We will first deal with the preliminary objection of the learned ASG with regard to the filing of the second set of appeals before this court challenging the order of the High Court dated 21st May 2024, that is on the point of maintainability. Stop.